Good morning. I'm Gary DeWaal, and this is Bridging the Week from November 4th to 15th, and today is November 18th, 2019. A social media company and its wholly owned subsidiary sued by the Securities and Exchange Commission for conducting an offering of an unregistered digital security claimed that the agency was wrong in its characterization of the crypto asset. The virtual asset was not a security, but a virtual currency, claimed the companies. Moreover, the defendants argued that the SEC has never definitively described when a crypto asset might morph from being a security to a virtual currency and was impermissibly enacting new regulation through its enforcement action against the defendants. Separately, a proprietary trading firm agreed to settle enforcement actions by the Commodity Futures Trading Commission and the Department of Justice by paying a $67.4 million sanction. The days are darker earlier these times, and cold has descended on New York City. However, the signs of the impending holidays are everywhere. So I can try to get out and enjoy some of the early decorations and the little light we have. Let's get started. Telegram Group Inc. and its wholly owned subsidiary, TON Issuer Inc., denied that its proposed issuance of Gram digital tokens last month would have been part of an illegal securities offering that began in early 2018, as alleged by the SEC in a complaint filed on October 11th. This is because, said the defendants, when issued, Grams would have constituted a virtual currency and/or a commodity and not a security under federal law. In its complaint, the SEC charged that, beginning in January 2018, the defendants raised $1.7 billion, including $424.5 million from U.S. persons in the first quarter of 2018, to fund the development of a proprietary blockchain, the Telegram Open Network, as well as their mobile messaging application, Telegram Messenger. The SEC claimed that the defendants' offer and sale of Grams to U.S. persons constitute an unregistered securities offering, and that Grams are securities because initial purchasers and subsequent investors expected to profit through Telegram's efforts to develop TON, including to attract sellers and developers to use the blockchain, as well as to promote Grams. In their answer, defendants said that their fundraise from U.S. persons was conducted pursuant to a valid exemption from Securities Registration Regulation D. They argued that what investors purchased in 2018 were investment contracts for a cryptocurrency. However, because the blockchain in which the cryptocurrency would operate was to have been completed and operational by the time the cryptocurrency was scheduled to have been issued on October 31st, 2019, the virtual asset would not have been a security at the time it was issued. Thus, any resale restrictions that would ordinarily apply to a Regulation D issued security would not have applied to Grams. Defendants claimed that their position was supported by public statements by SEC Chairman Jay Clayton, as well as William Hinman, SEC Director of Corporation Finance, that the initial issuance of a virtual asset, such as Ether, might constitute a security offering, but the virtual asset over time could become a cryptocurrency. To me, it is ambiguous what are the agreed criteria to determine when a security token might be deemed a virtual currency. Certainly, there is express criteria in an analogous situation to determine when a futures contract on a stock index is under the exclusive jurisdiction of the CFTC versus the joint authority of the CFTC and the SEC. To me, the crypto industry should have similar rules before the SEC wields its enforcement hammer. I have more details on this distinction at the SEC and the CFTC regarding stock index futures on the blog site. You know where it is, www.bridgingtheweek.com. Check it out. Tower Research Capital agreed to pay $67.4 million in restitution, disgorgement, and a civil fine to resolve allegations by the CFTC that it engaged in a manipulative and deceptive scheme and spoofing in violation of applicable law from at least March 2012 through December 2013 because of the purported spoofing activities of 3 ex-employees. Simultaneously, the company entered into a deferred prosecution agreement with the Department of Justice related to the same activities by also agreeing to pay a $67.4 million fine as a criminal fine. criminal disgorgement, and victim compensation. However, under the CFTC settlement, any amounts paid by Tower to the Department of Justice will offset amounts otherwise owed to the CFTC. According to the CFTC, the three traders engaged in spoofing trading, quote, on thousands of occasions, end of quote, during the relevant time, on futures contracts listed on two CME Group exchanges. In the Tower settlement, regulators credited the firms for their cooperation in their investigation and the adoption of comprehensive remedial measures. However, Tower sanctions were still very large. In fact, the largest total monetary relief ever ordered, said the CFTC. That is, in a spoofing case. Moreover, the amounts of Tower fines seem arbitrary and not grounded on a clear basis. As a result, credit may have been given for the firm's cooperation, but the benefit is not apparent. In a recent speech at FIA Expo, CFTC Chairman Heath Tarbert intimated that the Division of Enforcement would soon be publishing enforcement penalty guidelines. It would be helpful if these guidelines explain how the Division of Enforcement determines its asking price for settlements and how cooperation precisely factors into final settlement calculations. Today, these determinations are not transparent at all, and potential defendants are often dumbfounded when staff first proposes a settlement amount in resolution negotiations. And finally, 3 months after the National Futures Association levied a substantial fine for the same conduct, the CFTC assessed Wells Fargo Bank a $10 million fine for purportedly not dealing with a swap counterparty in good faith in connection with disclosures related to the pricing of a 4-month Canadian dollar forward contract sold to the client in 2014. The CFTC claimed that Wells Fargo told the customer that it would set the settlement price for the forward contract at the average price of Canadian dollar spot contracts Wells Fargo purchased on August 27, 2014. In fact, said the CFTC, Wells Fargo priced the forward contract at a higher price Wells Fargo thought the client would accept and not at the average price. Following its own internal investigation, Wells Fargo terminated the relevant employee and undertook certain remedial measures. In addition to agreeing to pay the $10 million fine, Wells Fargo agreed to restitution to its counterparty of $4.475 million to resolve the CFTC's enforcement action. However, the amount of the ordered restitution is deemed satisfied by prior restitution by Wells Fargo to the counterparty. It makes no sense to me to order restitution by a defendant in an enforcement action where the restitution previously was voluntarily made by the defendant, other than to garner headlines of a bigger aggregate penalty. The CFTC's press release announcing the Wells Fargo settlement said told of the order of restitution and includes the amount of restitution in the headline and body of text, but makes no reference to the prior voluntary payment by Wells Fargo, although the settlement order references the prior payment. This practice seems terribly misleading at best. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a nice week, and until the next edition of Bridging the Week, ciao.